Today we're going to be doing Clerk of the Court, Nature of the Office in American Jurisprudence. And we're going to have Black's Law Dictionary, 9th edition, handy to help us with any words we have, because we do not want to leave any word behind. So let's get right to it. There we go. Okay, so the scope of this article discusses the nature of the office of Clerk of Court, the appointment, qualification, and tenure of clerks of court, their compensation, and their powers, duties, and liabilities. So we're going to go over the nature of the office. We're going to figure out how the clerk of court is appointed. We're going to look at what their qualifications must be for different courts, and the tenure of the clerk of courts, and their compensation. And then we'll look at their powers, duties, and liabilities. So the federal aspects are federal statutes that provide for the appointment of clerks of the various federal courts, as well as the duties of those clerks and their compensation. So that's where our federal aspects will be. And then we have a bunch of other things that are treated elsewhere, some of which we've gone over in previous episodes. So just checking to see if anyone's still in the room. If you would, please hit the thumbs up or just say something in the chat so I know you all are there. And we're going to start with this right away with nature of the office of clerk of the court generally. So a clerk of a court, also sometimes called prothonotary, is an administrative officer, an agent of the state, or a ministerial officer of the court. So a clerk is prothonotary. So we got prothonotary is an administrative officer and an agent of the state. Or, okay, so it's an or. So you're either an administrative officer as a clerk of a court, depending on the court, an agent of the state, or a ministerial officer of the court. The court clerk is clothed with official functions of a highly important nature, but may be considered merely a functionary of the court, or a mere recording officer. Mere recording officer is the clerk, the nature of the clerk. The office of court clerk is part of the judicial branch of the government. As an arm of the court, the clerk of the court is subject to the direction, control, and supervision of the judge of the court, even where the court clerk is elected by voters. But the office of clerk is separate and distinct from the office of judge. Boy, we got a lot of footnotes on this, so let's see what the observation is first. Appointed clerk magistrates are the face of the district court, since they are often called upon to provide information, as opposed to legal advice, to persons seeking relief from the court as to how the court system works, what they need to file, and how to complete forms. So if we have anyone out there still, look at this observation. Appointed clerk magistrates are the face of the district court. Okay? And since they are called upon to provide information as opposed to legal advice. So they're providing information, not legal advice. Persons seeking relief from the court as to how the court system works, what they need to file, and how to complete court forms. So that's the appointed clerk magistrates are the face of the district court. So that's footnote 13. So let's look at some of these here. We'll start with that one. and that was in Massachusetts Municipal Court, Chief Justice of Boston Municipal Court, 2019, rather recent. There's another one, 2019. So let's look at this again. So there's a lot of recent cases that have been looked at as far as the nature of the office of the clerk of court. So we have here the prothonotary, and that's Brown versus Levy, and that's 1999, Pennsylvania Superior Court. And then we have administrative officers, footnote 2, and that's State versus Jackson, West Virginia, 2011. Wow. Agent of the State, number 3, and that's Campaign for Southern Equality versus Bryant, and that's in Southern District of Mississippi. Agent of the State was number 3, and that was Mississippi 2016, applying Mississippi law and holding that circuit clerks are county officials, notwithstanding the fact that their duties are established by state law. So in this one, they're county officials. That means that's number 3, and that's referring to agents of the state. Or a ministerial officer of the court. And that's number 4, and that's Bureau of Driver Licensing in Pennsylvania. There's another one in Florida, 2nd District Court of Appeals in 2009. Use 18 USC 20 if the clerk or official messes or obstructs any documents. Well, perhaps. It's okay, Justice Berserker. Actually, we're just getting started. We had a little diversion at the beginning, so we're actually just getting started here. We're on the generally about the nature of the clerk of court. So on that, the USC, we're going to look into where there's liabilities. That's going to be in the liability section, and I'll bet they'll have references to that code you're referring to here, because they always have references to USC when we get to federal aspects. All right, let's proceed. And I think we hit all these different ones here. Okay, and clerk is clothed with official functions of a highly important nature. And that's number 5. And that's State Board of Retirement versus Bulger, Massachusetts. That's 2006. But may be considered merely a functionary of the court, and that's number 6. So Donahue versus Secretary of the Commonwealth, I think that is Massachusetts, 1988. Or a mere recording officer. So if you really want to reduce their lowest capacity, number 7, and that's Connecticut, 2011. So it's judicial branch of government. 8 refers to, oh wow, 2nd Judicial District. That's 2001. Wow. Wow, that's pretty recent for something like that to come to light in case law. As an arm of the court, 9. Wow. Applying Missouri law, 28. Okay. The clerk of the court is subject to direction, control, and supervision of the judge of the court, even when the clerk is elected by the voters. So that's 10 and 11. Here we have 10 is looking at Section 43, which we'll get to later, and 11 is State versus Merrifield, West Virginia, 1998. And last one was the office of clerk is separate and distinct from the office of judge, and that distinction should be found in this case here in Ohio, 2010. So, wow. Pretty current stuff. The clerk is popular in recent years. Next section. Section 2. Office of the clerk of court as statutory or constitutional. So here we get to some important aspects. The office of the clerk of court is generally created by statute or constitutional provision, including court clerks under federal authorizing statutes. So, like we read before, for the federal aspects, there's authorizing statutes, right? Even the ones under federal authorization statutes, the office is generally created by statutes or constitutional provision. So where the state creates an office of the court clerk with the same functions as an existing local court clerk, the office of the local clerk ceases to exist. That's footnote 4, and that's Buchanan versus Wood. Looks like Oregon, 1986. In one jurisdiction, although a state constitution recognizes the clerk of the Superior Court as an officer of the county and designates each county as a body, corporate, and politic, neither state law nor the state constitution establishes the clerk's office as a separate legal entity capable of being sued. So there's part of on shockproof what you're saying there, right? If the clerk does commit some kind of official mess, it may be that, depending on your jurisdiction, see, it says in one jurisdiction, this is the beauty of American jurisprudence, is that we're trying to look at this from the principles of law regarding intent. And the jurisdiction here is going to matter a lot. So in one jurisdiction, meaning be careful what jurisdiction you're in, be familiar with your local laws, jurisdictions, your codes, whatever it might be. Although a state constitution recognizes the clerk of the Superior Court as an officer of the county and designates each county as a body, corporate, and politic, neither state law nor the state constitution establishes the clerk's office as a separate legal entity capable of being sued. Then performance standards for a court office are not constitutional requirements for performance standards for a court office. Now, there's plenty of statutory requirements. Believe me, you. And before I say anything further on believing me, be assured that this is not to be construed as any kind of legal, lawful advice, any way, shape, or form. This is strictly for entertainment and educational purposes. This is for exploration of American jurisprudence to further familiarize ourselves with the strength of our nation that we get to exercise as the people through American jurisprudence, but this is not to be used as any kind of advice or recommendations for any kind of actions, and do not do this at home. All right, let's proceed. Jurisdiction. So, interesting thing you say about the jurisdiction, because we could do one fully on jurisdiction. I think we did one before on it. And, one of the things about I'm not sure if I've done it or not, but we could do the next one on jurisdiction if I didn't. And one of the aspects of jurisdiction is that there's different aspects of jurisdiction that you can challenge at different times. And you want to be sure that you take care of, like, for instance, your personal jurisdiction early on so that you don't, miss an opportunity to dismiss a case based on lack of personal jurisdiction. However, once the case proceeds beyond, your initial pleadings, then it might be well off the table at that point. Of course, subject matter jurisdiction can be challenged at any point. But that's, with the tribal thing, I think it falls into some other aspects of jurisdiction that, from my understanding, if a tribe enters into any kind of a federal contract for any kind of funding of federal money, that there's almost always some type of clause in there where they'll be essentially forfeiting, de facto forfeit of their sovereign immunity, and therefore their jurisdiction over these kind of situations, I believe, in a lot of cases. So I think they're just kind of going by a false jurisdiction in most of the cases, but no one really wants to call them on the fact that their jurisdiction, as it may have been valid at some point, has become invalidated since they've entered into contract with the federal government for certain kinds of fundings and grants and such that come with those kind of provisions where their sovereign immunity would be, since from decision. Yeah, I have to familiarize myself with that. Again, what we're looking at here is an approach to looking at law from a common law point of view, and overall in American jurisprudence point of view, so that we can apply the tools that we have available to us through the system that they're designed to help the people achieve justice, and that when the system's moving properly, that these things actually can meet their true the realization of what their intentions were. So the law has to be applied correctly to function correctly. It can't just be written well. It has to be administered. It has to be executed well. So part of that is knowing how it should be executed, and understanding the American jurisprudence lets us know the ideal way and the proper way the law should be executed through the legal system. So, at that being said, if you proceed without establishing, without challenging your jurisdiction, it's, I think, de facto it's accepted. So that's why you need to make sure you put in your challenge to personal jurisdiction before you proceed with the trial. All right, let's continue here. This observation: a city ordinance that merges city clerk and municipal county clerk positions does not violate a state constitutional separation of powers provision, where that provision applies to state government and not to local governments. Let's see what that is. That's number 7. That is City of El Paso versus Arditi, 2012. All right, so that's an interesting observation here. So they pull in these really neat cases like this to give you an observation to highlight, so that you're aware that there's certain issues here that might be very similar to where you are, and understanding how it worked in this New Mexico will help you better. Texas. You can better prepare for any kind of curveballs that might come across in your cases. All right, let's proceed. Clerk of court as a judicial officer or public officer. Jurisdictions vary in their consideration of a clerk of court as an officer, some finding that a clerk of court is neither a judicial officer nor a public officer. In other jurisdictions, the office of the clerk is a judicial office, or at least a quasi-judicial office. And the clerk is a state or local officer when performing duties of the office of court clerk. Court clerk may be considered an officer of the court. Boy, we got a lot of footnotes in that short little paragraph. So jurisdictions may vary in their consideration of their lack of in their consideration of a clerk of court as an officer. Some find that a clerk of court is neither a judicial officer nor a public officer. So footnote 1 is, County of Cook, Illinois, 2000. And the other one here is Illinois also, and that's 2013. The clerk of a court is a non-judicial member of the court, and as such has no power to impose sentences or levy fines. Interesting. And that's in Illinois. So that's an interesting case right there. Worth looking up in detail. That's 2013. Number 2 is not a public officer, and that's Louisiana, 1989. Other jurisdictions, that is the court clerk is a judicial office, and that's number 3, and that's state 2nd Judicial District, Nevada, 2001. Or at least a quasi-judicial office. That's number 4, and that's Florida 4th District Court of Appeals, 2016. Jeez. City of Coral Springs, Zoba versus City of Coral Springs. I wonder what that case is. 4th District Court of Appeals, 2016. And that's saying, or at least a quasi-judicial office. Interesting. We got to look up this case here. Let's see. It's in the Florida Reporter, right? Okay. So, and the clerk is a state or local officer when performing duties of the office of the court clerk. the court clerk may be considered an officer of the clerk. So when they're doing the duties, 2013 Brown versus Levy back there in Pennsylvania, and the other one was Mississippi 2010 and Oklahoma 2008. Clerk may be considered an officer of the court. And it's a state or local officer when performing duties. Okay, craziness. So depending on your jurisdiction is the nature there of your clerk of court. So let's get a little deeper. Now that we have added confusion, let's see if we can make some clarity of it here. Appointment or election of state or local court, clerk of court, generally. The appointment or election of clerks of state courts, generally, is controlled by constitutional and statutory provisions. Court rule, 2, or municipal character, municipal charter, in the case of local courts. So that's the appointment of or election is controlled. So it's either an election or an appointment. It can be controlled by the constitution of your state, or it can be controlled by statutory provisions. It can be controlled by a court rule or a municipal charter in the case of local courts. In some states, the governor has the power to make an interim appointment of a clerk of court pending confirmation by the legislature. A state constitutional provision that all inhabitants of a state have an equal right to elect persons to positions where they will wield general governmental power did not apply to court clerks, who are considered merely functionaries. Jeez. Nothing else here but just the case laws here to look up. Qualification and eligibility of state or local clerks of court generally. So the eligibility for the office of clerk of a state court is governed largely by the constitutional and statutory provisions, back to that, some of which provide that eligibility must be determined prior to the assumption of office. The clerk generally must be a resident of the county or judicial district in which the clerk acts. Makes sense. Then there's a procedure for qualification. Procedure for the qualification of clerks of the court, clerks of the courts ordinarily is fixed by statute and rules of courts. Okay, so the qualification doesn't say here by constitution, it says by statute and rules of court. And in the case of the state court ruling that all candidates for the position of a court clerk receive a passing score on a written examination before their names may appear on the ballot. Wow, that's in Kentucky in 2001. Passing score on a written. I wonder who wrote that written examination that the candidates had to pass. That sounds like almost unconstitutional. I guess they do them a little different in Kentucky. Well, that's interesting. 2001, so it's not even that old. But again, they've probably been doing that way all along. They just finally got it encoded there. All right, oath and bond as requirements for qualification of state or local clerk of court. Let's see what they have to do here. The taking of an oath of office and the giving of an official bond are usual requirements for the qualification of a court clerk. So an official bond and an oath, two things. Statute governing bonds that must be posted by public officials before entering office does not prevent Superior Court judges from ordering a county clerk to post a supplemental bond as a condition of maintaining the county clerk's elected office, where the statute governing bonds required prior to entering office did not limit a court's authority to issue a bond during a specific time period. And a second statute allowed the court to order the clerk to provide a supplemental bond if the court believed the clerk did not have a good and sufficient bond on file. And when read together, the statutes did not conflict because they spoke to different actors and different subject matter. All right, good. We have a question because that was a tough one there. All right, so that means the clerk gives the judge trustee position and gives executor position to. I gotta read the rest of that here. Shit, where'd it go? That pictures the prosecutor over your finances and authority and jurisdiction of a case to get jurisdiction without your consent. So that means that the clerk gives a judge trustee position. No, the clerk doesn't. The clerk is a mere record keeper, really, or record custodian, so to speak. So a trustee of records. And it seems the blurry thing is that it's a judicial office. Separation of powers required to be such so that it's where the appointments are going to come from. There's going to be a lot of a lot of things that are going to come into play here that you have to consider when it comes down to what the clerk is going to be responsible for. Again, they're not. What I'm getting out of this so far is they're not really judicial. They have these qualifications of bonds, right? But I don't see where they're actually court officers. I'm just going to read in here to make sure I didn't miss it somewhere. I don't think it said anywhere here that they were court officers of the court. They can't give judgment. They're not really, or judicial officers, I should say. So again, the statutes did not conflict because they spoke to different actors and different subject matters. So what we're looking at is bonds. The court to order the clerk to provide a supplemental bond if the court believed the clerk did not have a good and sufficient bond on file. So yikes. All right, so that's again, this is what we're looking at here is the oath and bond requirements for qualification. So this might get into things where they're splitting here as far as posting supplemental bonds, conditions of maintaining the county clerk's elected office. So a few different cases here. It looks like we're in Montana, Kentucky, and Washington State. One was 1955, number 2. So this is giving of an official bond are usual requirements for the qualification. Okay, let's move on. Disqualification of state or local clerk of court from second incompatible office. A state or local clerk of court is disqualified from continuing in office, or the office may be deemed vacated by the clerk of court by accepting a second office, unless the disqualification is removed in a timely manner, as before the new term of office begins. A clerk is not disqualified from continuing in office by holding a position of trust under the United States when ordered into active military service. Position of trust. That's kind of a strange one there. Number 2. That's Kennedy versus Cook, 1940. Under some unconstitutional or statutory provisions, the offices of county clerk and clerk of the court may be unified, and there is no incompatibility in holding the office of clerk of court and being a member of the state assembly. That's number 4. Kay versus Kane, and that's Rhode Island, 1966. The offices of county commissioner and clerk of court are incompatible. 5. And that's 1967 in Idaho. So we definitely don't want to see the county commissioners being the clerk. Sounds like a conflict of interest to me. All right, let's move along. So, appointment of federal court clerks. Congress vests the power of appointing federal court clerks in their respective courts. And here's our USC, and we are looking for your saying about the 18, but this is actually about the clerk of international trade, clerk of district court. So this is their appointment of federal clerks. Right. Qualification and eligibility of federal court clerks generally. So, clerk required to reside in the district in which such clerk is appointed. This is a requirement, right? That's number one is by USC 28, and the clerks of each federal court are not eligible to hold specified incompatible positions. And I think that's what we just read. We're about to. Oath and bonds requirements, qualification of federal court. A surety bond may not be required of a clerk of federal court in carrying out official duties. The form of oath to be taken by clerks of federal courts is prescribed by statute. So it seems like the federal courts have, surety bond, 31 USC and 28. Right, so we get disqualification of a federal court clerk from second incompatible office, and the clerks of the federal courts are not eligible to practice law in any court of the United States and may not be appointed a commissioner, master, referee, or receiver in any case unless special reasons requiring appointment are recited in the order of appointment. That's 20 USC. All right. And now we're on to title to office of clerk of court generally. So the claimant to the office of clerk of court out of possession must seek statutory relief or a remedy by proceedings in the nature of quo warranto or mandamus. The title to the office of clerk of court cannot be assailed collaterally. A person appointed acting clerk of a particular court has no right or title to the office of clerk. So let's see, 1908. Oh goodness. Footnote 1. Okay, here it is right here. Wow. Mandamus. Number 2. That's AmJur. Okay, so the mandamus. So what quo warranto? Do we know what that is? Thought I did. We're going to find out because we have Black's Law. So we're going to do a quick search here. We're going to find out what quo warranto means. I think this is it. Here we go. Quo warranto. Beautiful. Quo warranto, also quo warranto. Law, Latin. By what authority? A common law writ used to inquire into the authority by which a public office is held or a franchise is claimed. Also termed writ quo warranto. Cases. Quo warranto. So there's a whole, okay, cool. An action by which the state seeks to revoke a corporation's charter. Wow. The federal rules of civil procedure are applicable to proceedings for quo warranto to the extent that the practice in such proceedings is not set forth in the statutes of the United States, and it has therefore conformed to the practice in civil actions. So there it is. Quo warranto. Okay, so important to know, look at it one more time here. By what authority? That's what that means in Latin. So we can just, by what authority? Quo warranto. this up real quick. Okay, that's how it does that. Cool deal. All right. Sorry, I gotta get back to where we were. Okay. The disqualification of federal judge, and now we're on to the next one. Title of office, clerk of court, general. A claimant. Oh, okay, so one we just read. Is it? No, it's a different one. Huh? Claimant to the office of clerk of court, out of possession, must seek statutory relief or a remedy by proceedings in the nature of quo warranto or mandamus. The title to the office of the clerk of court cannot be assailed collaterally. A person appointed acting clerk of a particular court has no right to title or to the office of the clerk. So that's strange. A person appointed acting clerk has no right or title to the office of clerk. Spell out which word? Quo warranto. It's right here. See it or not? I'll highlight it for you. Quo warranto. All right, let's get back. So, person appointed acting clerk of a particular court has no right or title to the office of clerk. That's number 4. That's New Jersey. Oh, quo, Q-U-O. Real quick here. Q-U-O, W-A-R-R-A-N-T-O. Warranty with an O at the end. All right. We're on to de facto clerks of court. One who exercises the functions of the office of clerk of court under an informal or defective appointment is a de facto officer. The principle that the official acts of officers de facto are to third persons of equal authority with those of officers de jure and cannot be collaterally attacked is applied in cases questioning the validity of the acts of de facto checks of court. So let's break this down a little bit more here. So one who exercises the functions, right? So remember, it's when you exercise the functions, you become a de facto officer. And that's number 1. That's Montana, 1985. Then the principle that official acts of officers are de facto are, as to third persons, of equal authority with those of officers de jure, which cannot be collaterally attacked, is applied in cases questioning the validity of the acts of de facto clerks of a court. And that's an old case from 55. So pretty interesting stuff right there. Quo warranto, yeah, Shockproof has it there. There you go, thanks. Excellent. So we got that there. Continue. And we're on to an hour mark, so we're getting pretty close here. Term of the office of clerk of court. So we're getting to our terms of 10 years here. The term of the office of clerk of court usually is fixed by constitutional provision or by statute. When the tenure of the clerk is not fixed by law, the clerk's term continues during the pleasure of the appointing power. So if your tenure of the clerk is not fixed by law, they just kind of continue until they piss someone off. Statutes fixing the term of office of a clerk of court must not violate constitutional provisions. And if the term is fixed by the Constitution, neither a municipal government nor the state legislature has the power to vary it. All right, pretty good stuff here. Then there's the vacancies in the office of clerk of court. So here's some of the reasons we can have a vacancy. Of course, check your state constitution. See, when this says no lawful incumbent, boy. So it's a failure to elect a successor after the expiration of the incumbent's term. Then vacancy may also be created by the clerk's death, resignation or removal, refusal to act. Wow. Depending, yes, exactly. Selected versus elected. Exactly. There's depending on your jurisdiction. Right. So let's look at these. A vacancy. These are reasons why you could have a vacancy created in the clerk's position: death, resignation or removal, refusal to act, failure to give the required bond, suspension from office, I guess so, acceptance of another office. A clerk may lawfully resign the clerk's office prior to the expiration of the term, but may not be reappointed to that office unless some other person has intervened as the deputy clerk and has intervened as the clerk by bona fide appointment. When the commencement, duration, and termination of the office of clerk are fixed by constitution or statute, also providing for the vacancies but not the replacement's duration or authority in office, the replacement serves for but the remainder of the unexpired term. So, again, check your state for that. And holding over in the office of clerk after expiration of a term. So these are ones where we have specific case law whenever there's incumbent's death or something like that, where you have vacancies if someone doesn't stay longer than they should. There's always going to be those cases. We can always find those here in American jurisprudence. So removal of clerks of court from office generally. So now we're getting into Section 18 here, and now we can start to get into the liabilities and the removal of them. So a clerk of court may be removed from office under appropriate circumstances as authorized by state constitution or statute or by the authority of the highest state court or through proceedings brought for that purpose. So what we get here is this is going to be a good place to leave off for next time, because we're going to get to procedure for the removing of the clerk, and this is going to be more about the liability side of it that we were talking about. But I really want to get through the foundational aspects of the nature of this office here. So once we understand the nature of the office of the clerk of court, we can start to understand. Let me write down this page here real quick. And that's Section 18, removal. This is clerks. Excellent. So then this will be another episode we can do, because I don't want to get too far over this hour mark like this, because this is a whole nother rabbit hole when we get to the removal. And then generally the liabilities will be the next part of this. So that will be a great way to introduce the topic for the next, or to divide the topic for the next one too. On that one, I'd like to thank everyone for showing up. It's been a great learning process here of the nature of the office of clerk of courts. realizing that there's a lot of vagueness and ambiguity into what they actually are, and depending on some of the mixed roles, where they're allowed to have mixed roles, where they're not. Uh, is it quasi judicial? Is it administrative? Is it a state officer? Just goes on and on about the municipalities, federal, state. All these different aspects play into the nature of clerk of court. And we also discovered that the clerk of court is not necessarily a judicial officer, so they can't issue judgments. They are record keepers and record holders. So, on that note, let's see if we get the outro here. We're going to have another episode of the Clerk of Courts where we'll focus on the liabilities and the removals and other aspects that go with the clerk. Because what we find is, it did say in American Jurisprudence here in the beginning, let me switch to this really quick because this was a really good statement that we should at least leave with to remember. In this aspect right here. Let's see. Officer is, see here, where is it? I want to say it's the, gosh, let me find it here. This is a good, okay, yeah, right here it is, the observation, of course. Appointed clerk magistrates are the face of the district court, since they are often called upon to provide information, as opposed to legal advice, to persons seeking relief from the court as to how the court system works, what they need to file, and how to complete court forms. And that's 13. Again, White versus Chief Justice of Boston Municipal Court, and that was 2019. So this has been recently established again. So this should be well held, established, and up to date. That we know that they're supposed to help you when you need to file paperwork, what you need to know when you're seeking relief from the court, and also how to complete the forms. However, they are not supposed to be delivering legal advice. So let's leave with at least this understanding of the function of clerk magistrates. And that way we can know that this pretty much applies when we're dealing with clerks of court, that they're not there to give legal advice, but they are there to help those seeking relief with understanding how the court system works, what needs to be filed, and how to complete the court forms. All right, that being said, I just wanted to leave on that note there because it was a great little concept that I wanted everyone to leave with, because it kind of encapsulates what we should expect when we personally go to a clerk of court and expect the type of service that they are basically, their duty is to provide the people with whenever we seek any kind of remedies from the court. On that note, I would like to bid everyone good night, and please subscribe, hit the like button on this one, and make sure you hit the bell notification so that you can be notified of the upcoming ones we have. And keep learning with us in American Jurisprudence. On that note, I'd like to say thank you again for everyone for coming, and I'll see you all on the next one. Peace out.